Catherine Amirfar.
And I'm Cal Raustiala.
And this is International Law Behind the Headlines, coming to you from
the American Society of International Law.
Hi, I'm Cal Raustiala, and welcome back to another episode of International Law Behind the Headlines. Today, we're going to cover an emerging, or I don't know why I'm saying emerging. It's a longstanding issue of international law, but it's one that has become more salient in recent years, and particularly even in recent weeks, which is the law governing outer space. And so as our special guest, we have Ina Popova of Debevoise and Plimpton. Ina is a longtime partner in international disputes and international law areas at Debevoise, a friend of ASIL as well, previously co-chair of one of our annual meetings, and I think has held other roles as well. So Ina, welcome to the podcast. Really happy to have you here.
Thanks for having me. Happy New Year.
Great. Thank you. So we're going to talk about space law, and there's a couple of things I just want to flag for listeners about space law that I think make it a timely topic for us. First, today, we're recording on January 8th. Today, there was a lunar mission launched, which appears to be a little bit maybe ill-fated. There's some issues with that, but it's one of the first such efforts in decades. So kind of a big deal. And then earlier, just a few weeks ago, there was a significant transmission from outer space using lasers of a video. So the transmission was a significant part. The video was, of course, a cat video, as all of the best internet videos are. But I think what's really significant about it is it illustrated or was proof of concept for a very rapid form of communication, which has all kinds of commercial and military and other implications. So a lot going on in space. And let's get into what's happening. So first of all, maybe you could tell us a little bit about that transmission that I just mentioned. Why is that significant, and what are the implications for international lawyers?
So if we've sent cat videos into space, I think it illustrates how we can send pretty much any other banal aspect of our lives into space, maybe. From a technological perspective, it's significant because it illustrates the advances that we are making in terms of communicating with space. It was an experiment to transmit data from deep space to Earth, and it happened at a rate 100 times faster than most advanced radio frequency systems. So it is encouraging news for communicating between the Earth and space. And it joins a relatively long list of other things that we've sent into space, which includes tardigrades, folk music, hair follicles, all kinds of things as we explore how we can harness space resources and how we can communicate with space.
It does seem like space resources have become increasingly significant. I mean, we were just chatting before we started recording and mentioned Starlink and the kind of key role that Starlink has played in the Ukrainian resistance to the Russian invasion. But of course, there are many other examples and extensive attention, of course, to Mars and colonizing the moon or Mars. And all of this, I guess, strikes me as somewhat fantastical, but I guess it's rapidly becoming less so. So maybe for our starting point, we could think a little bit about, first of all, satellites and remote sensing are two topics that I know are significant. There are thousands, 5,000, 10,000 objects in space. It's an incredible amount. There's increased use of remote sensing for various things. Of course, we had the Chinese spy balloon incident last year, which, maybe there was more heat than light around that, but it seemed to indicate some of the ways in which space was rapidly becoming more important geopolitically and as a result legally. So if you could help us understand the legal framework for thinking about these issues. So first of all, there's of course some older treaties, and maybe you could just walk us through kind of the basics of those, as well as more recent things like the Artemis Accords. So really start however you like, but what are the important things that international lawyers should know?
Okay, so space is crowded. I think maybe let's start there, and it's getting increasingly so. We need space, obviously, for many critical functions on Earth, from satellite TV to GPS. But with technological advances, we are seeing that there are more and more things that we can do with space and use space for. So this, and you mentioned the satellite communications, Starlink. There are initiatives to have mining on asteroids. So the more that we discover what activities can take place in space, the more things we send into space and the more crowded space becomes, which creates a need for us to think about how we use space responsibly and sustainably. And one of the things that we need to think about with space is that as it's becoming more and more crowded, there's collision risk and there's pollution risk. So there's a wonderful term called space debris, which is really sort of space junk, right? If you think about all the things that we send into space, a lot of them stay there and some of them come down, and sometimes there are collisions that could happen in space that create accidents and things like that have consequences for us here on Earth. So one of the technological advances that has caused this phenomenon is that we have been able to launch satellites into LEO, this low Earth orbit. This is closer to Earth than some of the more traditional orbits that are called the geostationary equatorial orbit, GEO, and the medium Earth orbit, MEO. And because it costs less to launch things into LEO, we have launched more of them. So one of the things we know is that the low Earth orbit currently has about 21,000 satellites. And estimates are that about 70% of the objects in the LEO are junk. So we need to think about how we're going to respond to that and how we can regulate it. So one of the responses to this phenomenon is space debris mitigation guidelines. So these are guidelines from the United Nations Committee on the Peaceful Uses of Outer Space, COPUOS. And there are a couple of guidelines that we can talk about, but these ones on space debris mitigation try to set out some guidelines for what we can do to reduce and manage the risks of collisions in space. These guidelines have been around for a while, and we're seeing a sort of two-pronged approach to this particular sustainability issue. One of them is developing technology to try to bring objects back safely. So one of the things we saw last year is the European Space Agency completed a first of its kind mission to guide essentially a dead satellite back to Earth so that it can achieve safe re-entry. And the other prong is regulation. So in late 2023, the US Senate unanimously passed an Orbital Sustainability Act, which is a bipartisan bill that aims to reduce the amount of space debris in orbit. So we're starting there, and we'll see what other efforts can be taken. But one of the things we could imagine is a global treaty to try and address the space debris phenomenon.
That's fantastic. So, I'm going to confess I don't know much about space law. And so I'm just going to ask you some naive questions here. But, just talking about the issue of space debris, I guess immediately raises, to my mind, questions around the oceans and the way that the oceans also are prone to pollution. And we've had various analogous sort of efforts to address pollution on the high seas. And of course, they both have the feeling of a global commons. But I guess maybe my first question in this sort of vein is space a global commons? Is it the common heritage of mankind? I don't know what sort of legal frame tends to be used with space. And are there strong parallels with the way we might think about the law of the sea at a conceptual level, or weak parallels, or is it deceptive? How do you sort of see that connection?
So one of the foundational instruments of space law is the Outer Space Treaty. This is a treaty from the 60s. So that tells you a little bit about the state of sort of the public international law of space. right? And I think there are some parallels with the law of the sea, some of the ones that you mentioned, and these questions about what aspects of space are or are not a common heritage of humankind are really important. What the Outer Space Treaty tells us is that outer space is free for exploration and use by all states, and there must be free access to all areas of celestial bodies, and state use of space should be in accordance with international law. But what exactly does that mean? What does using space in accordance with international law mean? And you mentioned sort of remote sensing earlier, and there are other treaties from around this time period that where there's a difference of approaches among nations. So another one is the Moon Agreement and how that sits with the Artemis program of the US. So the 1979 Moon Agreement says that the moon and its resources are the common heritage of mankind, and it prohibits claims of state sovereignty or ownership over such resources. But only some countries have signed the Moon Agreement, and the United States and many other countries and spacefaring nations have not. And the United States' position is that the Moon Agreement does not represent customary international law. And the Artemis program reaffirms the importance of the Outer Space Treaty and takes the view that the extraction of space resources does not inherently constitute national appropriation for purposes of the Outer Space Treaty.
Great. You flagged Artemis, and I want to get to that in a second. But it does seem like in both the law of the sea context, maybe more traditionally in the law of the sea context, and in outer space, you have a situation. You used the phrase "spacefaring nations" just now, and obviously there's only a limited group. I don't know quite how big of states that are in fact spacefaring nations, but I imagine it's not a huge number that have the capacity. And then there's this interesting phenomenon now of private firms with the ability to get into space. So before we toggle to Artemis, I guess I have a question about the private sector. So can any private company with the technological wherewithal just launch something into space, or do they have to get some sort of approval from someone, or sort of what are the limits on private actors acting in space? The legal limits.
Excellent question. This is one area where we have a patchwork of national laws, essentially. And this is where we see the potential for conflict between those national laws. So there are some international instruments, some soft law instruments. In addition to the Outer Space Treaty, there's the Convention of International Telecommunications Union, which allows states to cut off private telecommunications which may appear dangerous to the security of the state or contrary to its laws. But query whether satellites, for example, are considered such private telecommunications. We also have General Assembly principles relating to remote sensing of Earth from outer space. So these are additional soft law guidance from the UN. And those guidelines say that remote sensing should respect the full and permanent sovereignty of all states and peoples over their own wealth and natural resources. And the remote sensing cannot be detrimental to the legitimate rights and interests of the sensed state. Now, there are also some rules about access to the data that has been sensed. But this is an area where, as you can imagine, there are differences in which states are doing the sensing and which states are being sensed, and what the rights of those states, how the rights of those states interact. So what we see right now is that states are passing their own national law frameworks for that regulate objects launched or registered in their jurisdiction, or operators registered in their jurisdiction, objects launched from their jurisdiction. And there is a potential for those different national law systems to be different and to potentially conflict in the future.
Yeah, interesting. So tell us a little bit about the Artemis Accords and specifically the US. I know there's some disputes or disagreements between the U.S. and some other major space nations about this. But first, maybe describe what Artemis is.
So the Artemis Accords are a program, a US-led program by NASA and the US Department of State and 7 other founding member nations. It was established in 2020. And they propose an international cooperation, a framework for international cooperation for returning to the moon and making scientific discoveries and exploring the moon. Now, this framework is not many states have signed up so far. We have about 30 odd signatories to the Artemis Accords, but this is about twice as many as the number of states who have signed up to the Moon Agreement. And so what we can see in the difference of approaches here is the Artemis program evidences some of the different approaches on whether state-sponsored commercial exploration and exploitation of the moon, how we should organize and think about those kinds of activities related to the moon.
Great. So when you say, first of all, the Artemis Accords, binding or non-binding agreement, and sort of what's their format? How do we think of them as a kind of legal instrument?
It's a program, and there is what's called the Artemis Accords, and so states can sign on to the accords themselves. The founding members include the United States, UK, Japan, Luxembourg, Canada, Australia, Italy, and the UAE.
I had the impression that, in particular, China had some concerns about Artemis, didn't necessarily agree with certain aspects. I guess I don't know enough about it, but I'm curious, does that seem accurate? And if so, where does China fall, or for that matter, any other state or set of states that has a different approach to the moon? Where do they fall in terms of their desires, their preferences?
Yeah. So you're right. There are states that disagree with the Artemis Accords, and they believe that it is essentially a claim of US-led and Western-led attempt to appropriate the moon in ways that those states consider contrary to the Outer Space Treaty. At its essence, the purpose of the Artemis program is to send crews to the moon. And states who disagree with this believe that this program, and Russia is one of them, this program and the 2020 executive order surrounding it illustrates that the United States is taking a sort of colonial approach to space. And they believe that this is inconsistent with some of the principles in the Outer Space Treaty and in the Moon Agreement about how we should use the moon.
I see. So was colonial a word that the Russians or Chinese actually used, or are you sort of paraphrasing?
I don't know that.
Okay. And is the concern that the United States is making or would make, or the Artemis signatories would make some kind of sovereignty or quasi-sovereignty claim over aspects of the moon? Is that sort of what's at bottom, or is this just general sort of dislike for the fact that the U.S. is leading this, or how do you sort of see what's the crux of the real disagreement between the U.S. and, let's say, Russia or China?
Well, I can't speak for what the intention behind the political approach may be, but the debate that it illustrates is whether commercial exploration and exploitation of space is consistent with international law, or whether we should have a different multilateral framework for exploring and exploiting space resources.
And is there any real prospect for a more UN-led equivalent sort of agreement? I know you referenced a few efforts earlier. Is that something that seems to actually be possible or probable?
Definitely possible. There's a UN working group on legal aspects of space resource activities. And the mandate of that working group includes developing an initial set of recommended principles for space resource activities that take into account the need to ensure that they're carried out in accordance with international law and in a sustainable manner. So there's definitely prospects for international engagement. Exactly what form they might take or how probable they may be is yet to be seen. I mean, there are lots of guidelines, but whether there's political appetite for a new international agreement or an update to the Outer Space Treaty is really anyone's guess at this point.
Yeah. I mean, these things seem so difficult. And so, I mean, again, to kind of toggle back to the law of the sea, obviously we're looking there at a decades-long process that still, in many ways, is kind of being developed. So I want to go back to something you mentioned earlier when you were talking about space debris and low Earth orbit, and you mentioned, I think, 21,000 objects, a lot of which are junk. It's sort of an amazing number. And I guess one question I had, and this sort of arose with regard to something else you mentioned, which is or maybe I mentioned it, which was the Chinese spy balloons. But either way, we talked a bit about that, which is really what is the boundary between air and space as a legal matter? And how do we think about, is low Earth orbit, in fact, in outer space? Is outer space even a legal concept? I guess I was sort of struck when the Chinese spy balloon thing happened. My understanding was there were people on Earth and maybe the Midwest who could see the balloons. And of course, they were big. And I might be wrong about that, but I had the impression from the news reports that they could see them. And so that just made me wonder, well, is that air or space? And then, of course, there are different legal regimes. So what do we know about that distinction, and how does that fit into some of what you were discussing about 21,000 objects and all of that?
So I think the spy balloon was probably could be seen because from reports, it sounds like it was very large, taller than the Statue of Liberty, right. With sort of a jetliner size payload, apparently. It's seeing a spy balloon drifting over your territory probably makes things a little more tangible than thinking about sort of thousands of satellites orbiting the Earth and imaging essentially the same thing, probably in similar detail. And that's something that happens sort of every day. To your question about how we think about where outer space starts, there isn't a settled international law answer to that, I believe. But there is this concept of there's a sort of conventional boundary between atmosphere and outer space. But I don't know that the definition of where space begins is universally adopted.
And it doesn't necessarily have legal significance. I mean, I guess it must in some way. I guess this is what I'm getting at. My understanding, and again, this is just naive Googling, was that there is a scientific concept, the Kármán line or something like that, that sort of distinguishes air from space or the atmosphere from space. But do the space treaties that we have or that are under development incorporate the scientific understanding, or do they just sort of elide the question entirely and don't really address where space begins? Because it would seem like the legal regimes are quite different, and there would be, in the liminal space between air and space, some pretty critical things that could happen. Like, for example, with a balloon, could you shoot it down or not? Can you use military means or not? Those things would I would guess turn significantly on where you actually were in this area. I don't want to use the word space to confuse it, but how far out from Earth you actually were. Am I right? Am I confused about that?
I think that is right. I don't know that there is a legal definition of outer space, and there are UN declarations. There's the Outer Space Treaty. I just don't know the answer to that.
Okay, so I guess just going back to the question of private actors and this recent launch, today's maybe ill-fated launch attempt, and of course there have been many others, through various private firms and even tourism that's been discussed into space. So I'm assuming this is going to be a big and growing area. Do you see that putting more pressure on the international community to develop a more clear set of maybe binding legal rules rather than a set of soft law or GA resolutions and so forth around outer space? In other words, are we entering a new phase, perhaps, of lawmaking around outer space that's really being driven by the private sector and the interest in the private sector? Does that seem accurate?
Yes, I think that's right. I think regulation of space is a little behind the curve of private activity, as you can see. And of course, it's easier to pass national legislation than international legislation. But just to take, for example, the remote sensing market, there are forecasts that it will reach somewhere near $5 billion by 2026. And last year, there were more objects than ever launched into space, which sort of makes sense. So as this commercial activity, not to say explodes, but continues developing at a very fast pace, that should provide some impetus for thinking about international frameworks. And this is the sort of dynamic in which it can make a lot of sense to have an international framework, because it is something that, by definition is not limited to national borders.
Yeah. Well, I think that's a terrific place to end. And I really appreciate you coming on, Ina. And I hope that as this area develops, which of course it's going to in the coming years, we'll have you back to talk about it.
Looking forward to it.
Great. Thank you so much.